presentations and litigation. This bootcamp is aimed This bootcamp aims to design you and equip you with as mooters for essential skills in oral advocacy, litigation, techniques, and persuasive legal presentation. So we hope that you will be able to learn how to structure your arguments, master courtroom etiquettes, engage with judges effectively during your oral presentations in September, and be able to deliver compelling oral submissions under pressure, especially when there are rebuttals, when there are questions, clarifications that need to be made coming from the bench, that kind of a thing. Ladies and gentlemen, I'm called Freda Nalumansi, and I'll be your host since we started the bootcamp. I want to warmly welcome our facilitators for this afternoon. From Ahabwe, and we also have Counsel Alan Manenji from Zimbabwe, all the way from Zimbabwe, from the National Regulator's Office, Fortress. A warm welcome to you. Thank you so much for gracing this session of our bootcamp with your presence. And we really look forward to hearing from you and learning from your great, vast experience and expertise that you will bring on board. So before we start, I want to give 1 minute to each of our facilitators to just say hello to all of you. For the rest of the participants, the mooters who have not yet joined, they will join along as we continue, because we've already lost some time because of late arrivals and trying to buy time for others to join. So right now I invite Alan from Fortress. Mr. Manenji, you're welcome to say a few words, just hello to our mooters in 1 minute. And then we can also hear from Peter. Over to you, Alan.
Thank you very much, Freda. Thank you very much, everyone from Unwanted Witness. It's such a pleasure and an honor to be invited to facilitate, to be one of the facilitators of this bootcamp. And I'm looking forward to sharing what I have prepared with everyone, and also learning from the other facilitators, and also learning from the participants through the questions and everything that they'll be posing during this session. I hope it will be interactive, and I hope I will be able to contribute to the successful journey of your mooting journey. And thank you so much for having me.
Thank you so much, Alan. Can we hear from Counsel Ahabwe?
All right. Good afternoon.
To you, Peter.
Yeah, good afternoon, Freda. And I don't know, at Soki we call them fellows, so I don't know if we'll call them mooters at Unwanted Witness. It's a delight to be with you this afternoon, and thank you to also my co-facilitator, Alan, who is joining us all the way from Zimbabwe. It's a delight to be here, and I hope that we can have meaningful deliberations and sharing, exchange of knowledge, and looking forward to, the session. Thank you very much.
Thank you, Counsel Peter. Without wasting time, I wish to invite Counsel Peter Ahabwe to take us through the first two modules that relate to foundations of oral advocacy and courtroom etiquettes and professionalism. which he's going to do from now until about 3:30. Over to you, Council Peter.
Wonderful. So firstly, thank you, Freda, and the team at Unwanted Witness. I want to say a huge thank you for the work you're doing to create the next court bulldozers, world-class litigants, and the next change makers on our planet, not just Uganda, but the globe at large. So thank you. Thank you very much, Freda and your team. And thank you for extending an invitation to us to facilitate this. My name is Peter Ahabwe, as I've been introduced. I am a lawyer, an advocate, and I serve at an organization called SOKI Initiative. You could check us on all our socials, Instagram, X. I serve there as the coordinator for the SOKI Moot Court Fellowship, which we run. I see somebody's hand is up. I want to be sure. I don't know if somebody was putting up the hand. All right.
No,
all right.
Peter, just proceed.
All right. Thank you, Freda. But I also wanted to say that I serve where I work from, and a bit of the other work that I do. I am a business development manager at KTA Advocates, and that is in Kampala. So that's pretty much about the work that I do, and I'm very, very delighted, but I'm fanatic of Moot. So quickly, let's get into it. I think before because I wanted this to be a little conversational, so I want to be sure of the audience I am addressing. By show of hands, how many of us would consider that they have mooted? I don't want to call you novice, so they have mooted once or twice. You could just use the emoji and show me in the chat. I want to be sure of how I could go on so that it's a meaningful engagement. If you've mooted more than once or twice, engaged in a moot court competition once or twice, okay, so once or twice are the hands that I need. So I see Cornelius, I see Mwaruka, I see Florence, I see Mokisa, I see Mariam. Okay, wonderful. So we have some good novice. Okay, all right. Okay, so you can lower your hands. And if you've done a moot competition more than 3 times, and you've even done a competitive one, if you've done more than 3 times in your law school journey, by show of hands, I want to see those. Okay, anyone? Now those are what we call the intermediaries. What the first ones were the novice or the beginners, and then I want to hear from the intermediary. Oh, we also have Mwaruka there. Okay, let's try and use our emoji there. I just want to see the hands because I want to be sure that we benefit from our discussion. Okay, Florence has also. Okay. Okay. All right. And then if you've done this competition, if you've done and even participated at an international level, if you've gone for like Unwanted Witness, All Africa Human Rights Moot Competition, the JSAP, or you've done IHL from your country. I'm mentioning moots that are quite common here in Uganda because I'm based in Uganda. Okay, again, Mwaruka has done a competitive moot. Okay, all right. So if you've done like Unwanted Witness, I'm not sure, Freda will clarify. I'm not sure if they permit people who have done to always come back. Great. So the reason why I asked that is because I wanted to begin from that discussion so that I get to understand the demographics of the people that I'll be addressing. So I can see we have a little bit of the novice. So some of the things that I might say, I'll try and be deliberate in explaining them so that we have a grasp. So I was tasked to train on 2 models or 2 modules. One is the foundations of oral advocacy, and we'll basically go through the understanding of the moot courtroom and its dynamics. And then the other is the moot courtroom etiquette and professionalism. And that regards rules of the court of conduct, and then the confidence, body language, and advocacy. So at SOCI, when we're doing this, we usually would prefer that they are physical, but nonetheless, we'll do an online. Maruka, you could lower your hand. I want to be sure that you're not maybe raising it for a question. All right, so we could start. So let's start. I want to offer this presentation in a kind of a three-structured phase. Firstly, I'm going to deal with the role of advocacy in mooting and litigation. So I have simplified the role of advocacy in mooting and litigation in terms of about three things, right? The first thing, the role of advocacy is to ensure that you understand the needs of your client. That's advocacy, right? Understand the needs of your client. And the needs of your client is that unwanted witness has prepared a moot court problem. And that problem has a need that it seeks to address. So as you listen to me this afternoon or morning or afternoon or morning, wherever you're joining from, the biggest question that I want you to ask is, have you understood the need of this year's moot problem? That's the first thing. And the need goes into reading the moot court problem and understanding it. So oral advocacy, one of the first roles, it enables you to have an understanding because it brings out the nitty-gritties of the moot case problem. You get to understand that they are unearthing new principles under, privacy law, new principles under, cyber law, and things of that nature. So you get to have an understanding of the needs of the client, and the needs of the client are found in the problem. Secondly, you get to generate solutions for the client. And how do we generate the solutions, or how does oral advocacy enable you generate solutions? Is that when you've understood the need of the client, and then you're able to tailor solutions. And that feeds into reading the law, the particular law that is addressing that particular section or area of the law, and in particular here, most particularly unwanted witness, it's privacy law. So you get to generate solutions, and it's one of the roles of advocacy. And I hope that I saw my colleague Alan has a presentation. I believe that he might have extra additions to touch on that. The other is that once you've been able to generate solutions, right, for the client, then finally, one of the other key roles of litigation is to advance a critical and progressive appreciation of the law. So there are three things that I've summarized the role of advocacy. And the last one, you could actually simply call it advocacy. You advocate for your client. But the first thing is understanding the need. Then the other is generating a solution. And the last one is really advancing a critical and progressive progressive application of the law. That is in terms of litigation, because you know that when we advocate, we introduce jurisprudence. So the role of this bootcamp is to help enable you to understand that you as future advocates, litigants, you're going to contribute to the jurisprudence of privacy law in your countries and the Africa as a continent. Yeah, so it's very, very important. So I would just summarize that in terms of the role of advocacy. There are a couple of things that I think I would, if just that topic alone, I would take a full day. But I tried summarizing it because of a time and presentation. So those are the first things, three things that I needed you to take advantage. Now let's get to the structure of the oral submission in a moot court. And the fact that I've seen we have about 4 or 5 novice speakers is that one of the first things that I will tell you is that a moot can be structured in just 3 things. You have a problem, and then you have what we call parties or representation, and then you have the moot itself. Now, we'll get into the structure of the moot submissions, but I wanted to begin with a problem. Each of you was sent this year's moot case problem, and you have it, and you've perused it, and you're trying to read it in every page to cover. The very first things that SOCI we do is that we do what they call a moot case exposition. So we get into the nitty-gritties of the problem for you to understand. So that means that that context, you're able to understand what area of the moot problem is addressing. I wanted to start with that. Then you get into the parties. You get to understand who is suing who. Is it an organization? Are they two entities? Is it an individual? Who is suing who? And that's very, very equally very important. And then we get into the initial, which you dearly call the moot itself. And that's a very pertinent area because the moot is where we get to understand what parties. So you have a petitioner or the applicant, and then you will have the respondent, and those are the two sides. So in terms of the structure of the oral submission is that in terms of oral advocacy, it's the art of ensuring that you represent what you've put down in writing. And so I will offer this guidance in terms of a three structured. Firstly, is that in terms of the basics of oral submission in a moot court setting, one is I want to offer it in terms of structure of your speech. The other is that I'm going to offer in terms of I've seen key differences between oral submissions and written oral submissions and then oral arguments. I'll also offer that in terms of that will speak to the judge's questions particularly. And then I will come to the crafting of the compelling arguments and then legal precedents effectively, and then persuasive delivery techniques. So if we turn to the structure, firstly, is that in terms of the oral presentation, I'll just give you an example. In terms of structure, you begin by making mention of who you are before the court. Now, please, I would use my name, so I wouldn't want to use my name, and then I will use unwanted witness as a client that I'll probably be representing against the state of Uganda where I come from. So in terms of representation, like I said, you go on to say who you are, write your name, then you state your issues or you state the facts, and then you do what they call averments, right? And then we'll come to the signposting. So for example, I'll just give an example. In terms of, because like I said, you draw the roadmap. So it's majorly in terms of drawing the roadmap. So firstly, you begin by making mention of, if it's a morning, it's an afternoon, like now, you say, good afternoon, Your Excellencies. My name is Peter, lead counsel or lead agent, because it's an international moot unwanted witness. You also have to be cognizant of the audience that you're addressing. And if you're addressing them from the jurisdiction of your country, where I believe that Uganda usually for the unwanted witness, you submit before judges of the High Court, you will have to refer to them as your lordships. So you kickstart your presentation by saying, may it please you, your lordships, my name is Peter. I have a lead counsel for the applicant, and I have been accorded 30 minutes of this court's honorable time. And with me, I appear with my colleague, Alan, and my colleague, Patrick. We've been accorded 30 minutes. I will use 5 minutes to give the facts that give rise to this matter, and I will give key substantive submissions in terms of issue 1, which is in respect to this matter. But before I delve into the substantive discussion before the court, I would like your lordships to give facts that give rise to the matter before this honorable court. So it's just one of the ways that is in terms of your structure. It's just one of the ways that you structure your speech. It sounds a little, signposting, and you're giving the judges a roadmap. So the first thing that I have said, please introduce your name, introduce maybe the team, and then the side you add. And then we go into now again in terms of the signposting. So the pertinent things, those are structure now, because we're talking about the structure. The other thing that you now need to pay keen attention after you've done that is the signposting. You say, for example, now you say, Your Lordships, I now turn to addressing you, particularly when you're done maybe with the facts, because you said, like I said, you'll just give a summary of the facts. Then you say, Your Lordships, I now turn to the issue one, which concerns this, and then you go on to say issue one, and I will address issue one, which concerns whether the state violated the rights of the unwanted witness by closing down internet for 15 days, whether that was a violation of this article of this convention. And then you say, in response or in, analyzing this issue, I'll address it in two header varments. Firstly, that indeed there was a violation of this right, and secondly, that the state did violate international treaties and obligations as per these conventions. So it's very, very important that you do that, and then you be able to move on to the next. It's very, very key to use that kind of signposting, because the judges, your lordships, get to know that you have finished this and then you're moving on to the next stage. So it's just one of the other things. And again, about the structure, because I want to do this in a very summarized way. It's very important that once you've closed out your issue or your argument, you summarily give a closing statement or an overall closure of your roadmap. You say, maybe you can use something like, for these reasons, Your Excellency or Your Lordships, we submit that indeed, in respect to the first averment, the state has indeed violated its obligation as per required under Article 15 of this treaty, of this convention, and therefore we submit that it has violated this treaty. And then you could go on very, very tactfully before the judges and give a very overarching argument when you're done with the two, an overarching conclusion when you're done with the two averments. And you say, for these reasons, Your Excellency, and particularly in respect to issue one, we submit that the state should be found at fault for violation of the right to privacy as seen under Article this of the treaty, and a violation of this international convention, and as reiterated in the case that I had earlier cited. And for these reasons, we submit that indeed you violated you violated these rights. So when you do that, that creates a kind of a structure of your oral submission from the court. But before I leave this submission, one of the pertinent things that I want you to pay keen attention is, firstly, like I said, in terms of the oral structure, is draw a roadmap. So who are you right before the court? Are you the lead agent? Are you the So make mention of who you are, make mention of your name, make mention of the issue. What issue are you addressing? And if you're the lead, if you're the second agent, you can say, Your Excellencies or Your Lordships, as earlier introduced, I am now maybe Alan. I will be submitting on issue 2, right? And then you need not to go here. Then, Your Excellencies, I'm now Mulungu. I will be addressing the third claim and making prayers before the court. So you're creating a structure of your oral submission, and you say, I just will be addressing the court on claim 3, and then finally making the prayers. But I will address claim 3 with one header varment or two header varments. So you're signposting so that the judges get to know what kind of direction you're taking. And then at the end of the day, where are you taking them? So I've been also, so that's essentially generally, and I can maybe later take on questions, but this is something that we usually at Soki unpack in about 3 or 4 trainings, but I've tried to squeeze it in the last or so 5 minutes. And that's essentially how you come up with a structure of your argument. But now I've been also asked to talk about key differences between written and oral arguments. So one of the things you will notice is that there isn't key sort of differences that are between written submissions and oral arguments. But what will create the difference is in the following things that I'm here to talk about, because one is just that you get on your laptop or computer and then draft these very brilliantly executed memorials and then just send them in. And then you find that in terms of the oral presentation is where you're required to demonstrate your application of the knowledge so in terms of really format, so the first thing is just for the form. The form is that for the written arguments or written memorials arguments, in terms of the structure, how should it appear? Did you follow this as a structure? Did you footnote things like that? Did you use an averment? Do you have a heading? And that does not appear when it comes to like an oral argument, because the oral argument, you're in a kind of a very you're now in the ring, so you're supposed to be as expressive and adaptable as possible to be able to answer. The other thing that I think I needed to answer is that one of the things that you'll also see key unique differences between oral and written is something that is about, I think, one of the other things that I thought was about maybe depth and detail. So you might find that in terms of structure, you might be concise when you're structuring your argument, and then you're not very detailed and then not very authoritative. Some speakers choose that. And then when it comes to oral arguments, because of maybe a lot of time or limited time, you're more expressive, you're more coherent, you're strong on your points, you're more persuasive, you're more detailed, and you use every technical bit to bring out your point. So that's the other thing. And then the other difference is that really for written submissions, you're not interacting with anyone. So you can see now from where I am speaking to you and you're listening. So that creates a difference, because the oral arguments is that you have an audience which you're speaking directly to, and then there's that interface and interaction. So equally, that's very, very important. The other thing I think is in terms of delivery or style or demeanor. So in terms of the written submissions is that you have like, I'm guessing Unwanted Witness told you that you need to structure your arguments in this format, and they need to be on these pages, and you need to follow this. So that's in terms of delivery. But with the oral presentation, like the way you're hearing me, is that I am only confided in the time I'm given, and I need to work within that. So those are just the key differences in terms of the oral and written submissions. The interface delivery, the fact that you just have an interaction with the audience, and then the other you don't. So those are some of the key differences that you will notice in terms of the written and oral arguments. But one of the things that I wanted to emphasize here before I leave this, I have to tell you, and this is something I think Unwanted Witness has been emphasizing, your oral argument should be as good. No. Your written argument should be as good as your oral argument. So let me just put this. Where written pleadings can actually pass a test for your qualification to just say, this is an excellent team, before I even hear them in an oral sense. So like they say, a litigant's pleadings speak for themselves. Please ensure when you're drafting your pleadings and your oral arguments, they are as excellent, as astute as it can be, so that when I read your pleadings, I have no question. I just say, these were drafted by Freda. They're very excellent. And by the time Freda opens up to speak to the judges, it's excellent work. So please ensure that you speak to the judges before you even meet them on directly at the bar. So it's very, very important that you draft very, very clinical written arguments, so that you speak to the judges before even they meet you. All right, so let's go on to the art of persuasion. Now, oral advocacy is entirely about persuasion. Like, I would give it, I think, out of 100, I would give it a 99 or 90%. The take is the demeanor, and the pose will come to that. But persuasion. And persuasion is really the art of ensuring that you use three things: the argument that you present before the bench, and you persuade them to believe you persuade the bench to believe that you are making the most logical argument that they will have ever had in whatever hard situation you're in. The reason why I say that is that some of you are going to find that you're on sides that are extremely complicated, and you're now wondering, I am the respondent. I will tell you for a fact, the time when I moved at law school, for all the moots that I did, I loved the respondent side. Why? Because I listened to the allegations of the applicant and I make key responses. So how do you craft a compelling argument? We'll go back to the basics. Firstly, it's to understand your issue. What's your issue about? Your issue could be whether there's a violation of privacy rights. That's the issue. But how do you summarize that issue, right? That issue can be summarized in two ways. You would begin by understanding what privacy rights have been violated. And then you get into what within the facts show that indeed the right to privacy was violated. So that's the first thing. Then two is generating compelling, persuasive, right? And in tandem authorities with that issue. Because when you don't have the arguments, then you can't create a compelling argument. So number one is get authorities. So get, if it's a conversion, get to read it. What particular provision of the conversion, right? If it's a case that has been decided in courts of Uganda, courts of whatever country you come from, Zimbabwe, like my brother Alan, ensure that you have the law that has interpreted that particular provision. And that's one of the ways that you create a compelling argument, because it's backed up by both fact and the law. So it's very, very important. And that is one of the techniques that you create a compelling argument. And I'll give you a technique. So if you find that the issue is whether there has been a violation of the right to privacy, go within your facts, read particular paragraphs that feed into that issue. That's number one. So when you're qualifying before the judges, this is how you could sound. Your lordships and your excellencies, in respect to the issue in regards to violation of the right to privacy, paragraph 22 of our case of facts states that the state of Uganda closed the unwanted witness, and please, Freda, forgive me, this is just hypothetical. It closed unwanted witness offices for 5 days without any, court order. They did not inform them. There was no notice, and they closed it for 5 days. Article 5 of the unwanted witness conversion states that anyone who does, close offices or does this for the last 1 day without a court order has indeed violated. I will persuade this court by relying on the decision of Unwanted Witnesses versus Uganda, a decision of 2024, miscellaneous this in the High Court of this, where Justice Musa Sekana did clearly state this. And then you're referring to that, and then you persuade it and you use it into you. So that's one of the ways that you create a compelling argument. So you have the law, you have the issue, the facts that state there, you have the section of the law or conversion or particular article of the Constitution, and then you go to the treaty, and then you go to case decided. You can even use commentaries. You can say in the writings of the unwanted witness, this has also been decided. That's one of the ways you create a compelling argument. The other is using of legal precedents effectively. Now, there are two things that I just needed to say about this particular segment of using effective precedents. I don't know if all of us know precedents. So precedents are essentially decisions of the court that have set a standard in an application of the law through their decision. So when judges pronounce themselves on a particular matter, they set a precedent. And so the application of those precedents are very key during the interpretation and application of the matter that you're always addressing before the court. So how do you then use legal precedents? Firstly, it's understanding principles. Please quote me right. Principles enshrined in those precedents. So if Unwanted Witnesses versus Uganda, miscellaneous clause 1 of 2024, highlighted 5 fundamental principles of the right to privacy, you go on to clearly state that, firstly, this is how you would use the legal precedents, that decision highlighted number 1, number 2, number 3, number 4. And you go on highlighting each of those to show their effect. And you say that has been relied on over and over a time. So if you find that decision of Uganda Unwanted Witnesses versus Uganda has been relied in a plethora of decisions, it's very, very important that you use them. Persuasive delivery techniques. Now, I had already given you a hint into that one, but usually there are three things that I give or we use for the delivery of persuasive delivery techniques. One is that incorporate facts in your case, because there you're persuading judges to believe and understand that they know. So you can say, with respect to this, your lordships, I refer you to paragraph 15, line 5 of the facts that says this. And once you've done that, that shows that you have knowledge of the facts because the judges score you on that. Secondly, the persuasive delivery techniques is that cite the law and then show how the law is gelling very well with the set of facts that you've given us. And then go on to use a decision of the court and enunciate in the decision what was given as a deliberation of the judges. And then when you're done with that, you can conclude that with a commentary or progressive jurisprudence, particularly affecting that. It's just one of the skills and styles to show that you're being tactfully persuasive before the judges. So we move on to module 2. It's the second, and which is the lighter one, and I hope that I'll be done, which is regards the courtroom etiquette and professionalism. Now, a little bit of a joke. You're not coming to address your colleague in the classroom. You're not coming to address, I see Michelle here, I see Florence here, I see Shaw, I see Issa, I see Jonathan, I see my very good friend, Mr. Joel Basoga is on the call. I see Lucy. You're not coming to our chat, yeah? So one of the things that I would say about courtroom etiquette is that please, as you prepare for this moot court, the etiquette of the moot courtroom is even how you address your colleagues, even before probably you get in the moot courtroom. That's one of the things that you would see, how you dress up, right? So dress up professionally. It's part of the moot court etiquette. Don't come in your shorts, don't come in your, don't come in a t-shirt when you're going to come in this unwanted moot. And I love the fact that Unwanted Witness over and over has always said that the students need to robe, at least from Uganda. I don't know, Alan, from my colleague from Zimbabwe. So you have to robe. It's court etiquette. It shows that you're professional, you're respectful to the judges. The other thing is, please ensure that you are in the courtroom before the judges. I just needed to highlight that some people, try to be around the courtroom outside. No. Let the judges find you when you're seated, and then you can be able to engage them. So in terms of the rules of the court conduct, one of the things that I was asked is addressing the judges question correctly. Now, all of you guys who are listening to me is that you have your structure that you've set out. You've written out your speech and you have particular things that you would like to have mentioned to the bench, maybe when you are starting to speak. But one of the things I will have to tell you is that a moot itself is not that you should be able to say everything that you've structured on your presentation, but it's majorly about how you respond to the judge's questions. And so in terms of addressing the bench's question, the first thing that I would say is that you need to always know that the judge is like the Lord in the moot court. Yeah. So never at one time when you're trying to speak, like the way I'm speaking to you now, if you see the judge even trying to speak, you need to pause and let them ask the question. Never speak over a judge or rudely interrupt them. It shows that you are maybe not composed, you are shaken. And then you're going to have issues with it. You need to be able to, sorry, I hope I'm still being heard. So the first thing that you need to work on is that you need to be able to have an overarching knowledge on your issue, so that while you're preparing, you get to ask yourself, what is the likely question that I'm likely to be asked about this as a litigant, as a presenter, So that enables you to have a preemptive mind to a likelihood question that is going to come. And that prepares you to answer. That's one of the first things that, in terms of judge, to be able to effectively answer the judge's question. So when you're preparing for this moot, please have at the back of your mind, they're likely to ask me, I'm the lead agent, what are they likely to ask me? So you know things about jurisdiction, things about, is the matter properly brought before the court? And that's all that you need to know. But then the other thing that I needed to say is that when a question is put to you, and usually this happens to oralists, is that you tend to look shaken. No. When a question is put to you, make it look like it's the most wondrous opportunity you've been given to shine. Why? And this is how you could do it. You appear very unchecked, you appear very modest, and you appear very unflustered. And you could even come up with a poker face throughout. And that enables you to, answer the judge's questions effectively. The other technique I could give you is that please always try and address the judges, but not in a very monotonous way, but with their titles. So in my time during mooting, we used to have, and which I know is still a very unique style, is that when the judge is saying, oh, Alan, I noticed that, what is your understanding of this principle of privacy law? And so when the judge is asking a question, one of the ways to just get into their mind is that you say, may it please you, Your Excellency, or respectfully, Your Excellency, this question requires me to answer like this. And then you get to answer. So you appear very respectful, but then also you're getting into their mind. And then one of the ways is that you're quickly getting to know what kind of particular response you needed to make at that particular time. So it's a very respectful acknowledgement before the judges, but it also aids you to be able to conjure, come up with a solution in that heated time. So when a question is put to you, you say, oh, Your Lordship, oh, my Lord, oh, Your Excellency, I see that your question intimates this. And in response to that, I will make 2 key submissions to that particular question or something like that. So you get to notice that you're now answering particularly what the judge wants, and then you're moving on to the next segment. So the other thing that I've been asked to talk about is handling interruptions and judicial questioning. So I think I've already hinted on that when the questions are put to you, if they are a set, so I'm imagining that's one of the things I needed to answer about that. If it's a set, so if Judge Freda has asked you, Judge, I'm trying to use names here so that we keep attentive, Judge Innocent has asked you, then you could go on to use this kind of a style in response. So you could say, I'll make key responses, but firstly, I'll begin with Justice Freda's question. Justice Freda's question is about whether I have an understanding of the recent maybe protocol that was, I don't know, signed by these 2 countries. And then Justice Innocent asked me my understanding of whether the facts under paragraph 15 address maybe this. So you get on to address each of their questions, and in a kind of a very personal but very intentional manner. So the judges get to understand that you freely loved the questions, you seem unshaken, and you seem very okay to keep even going on picking the questions. Like I said, the moot is not really to fully address what you guys have structured as your presentation, but it's to address the judges' questions, because that is where the points lie. Yeah. So in terms of time management during oral submissions, one of the key unique things at SOCI that we do is that while we are training oralists, is that they need to have knowledge that key time management is very important. Why? Because my very senior colleague and brother who is on the call here, Mr. Joel, will tell you that when you go to this, I think Court of Appeal of Uganda, they will give you about 5 minutes to make mention of why your appeal should be entertained. So imagine you have such a very huge file, right? And I want you guys to apply this when you're even making your presentations for Unwanted Witness. You have a huge file, and then you have a client who you have tons and tons of pages that you've prepared and drafted. And then the justice, just like Justice Kiriabwire is a profound judge in Uganda, he will ask you that, why should we entertain your appeal? So the key thing we tell you in there is that, what's the summary of your case, right? What's the one thing that if they told you, if you're listening to me, what is the one thing that you need to make mention before the judges. And this is answers about the time management. You need to make mention. So begin with this. You begin with the end in the I like telling the speakers to have the end in the to begin with the end, in their mind. So you need to state what's your issue. So the issue is whether there's a violation. The violation is enshrined under this principle. This paragraph shows us there has been a violation, and then you get on to address it, right? So it's a quick way. And if your time is fast spent, please do not interrupt the judges by asking, unless you have been interrupted severally with so many questions. But you can say, Your Excellencies, some of you, your time gets done, and then they keep saying, but your time is done, and you're not even courteous enough to request. So it's very pertinent that during that time when your time is fast spent, you say, Your Excellencies, Justice Freda, I see that my time is fast spent, and as the president of the bench, I request that you accord me 1 more minute so that I can elucidate and illustrate to the bench, more particularly in regards to my issue 3. Yeah. And if you're the third agent, it's even more time for you to say, I request for 2 minutes to demonstrate this, and then I will make my key conclusions and submissions before the bench. So it's very, very important. I don't want to go till 3:30. I want to end at about 3:10 or 3:15. So let's move to confidence, body language in advocacy. So about your posture, please, it's very, very important that you do not lean in case usually unwanted witness their stance. So don't lean on the your posture. Don't appear like you're sick. Don't lean on the podium. Ensure that you remain in a kind of a very straight, formal, and presentable posture. You don't appear like you're sick or you're bored. And a kind of a thing here I wanted to say, there are kind of 3 or 4 sort of balances you have to make. One of the things that we see in moots is that there are people who appear overly very confident oralists. You want to appear confident but not boastful or arrogant, or like you're telling judges you don't know this stuff, because you know the knowledge. So you need to strike a balance there. The other is that you need to also come off as courteous, as cordial, but then also very in control. Very, very important. Yeah. So it's very, very important that you strike a balance between that. That's usually about. And then the others, the oralists here who are very calm. They are very, especially that's, please, this might sound sexist, but don't take it. It really shouldn't. They are the ladies who, but we've seen some of the ladies, they're just very calm, very, unmoved, but then don't come off as very non-engaging or, not very passionate about the case. So you have to strike a balance between those ends that I've talked about, especially when it comes to your postures and then speech delivery. In terms of eye contact, I usually give a technique. I wish this was a physical session, that you look over the heads. Yeah, nobody will ever tell you that they are looking straight in their eyes, but when you look just slightly above somebody's head, you'll be able to keep eye contact. And this eye contact is just not for the judge who has been posing to you there's so many questions. It's for all the 3. So roll your eye through the room. So from the first and to the last person, right? In terms of the gestures, please don't appear like you're a pastor who is telling people and you're casting all demons and telling people, please, that this is the time you need to receive the Lord. No. You can once in a while raise your hand. They need to be used moderately when you're using your hand gestures, so that the judges don't seem like you're about to jump on their necks. So hand gestures are equally very important, especially when you're being emphatic about a particular argument, and then when you're stressing something and putting across detail. It's very, very important that you use hand gestures, but not overly, but moderately. In terms of controlling your nerves and projecting confidence, I think the trick here is usually that I tell oralists that when you're at the podium, in terms of controlling your nerves, is that if you have a pen or if you have something, you could always hold on to it, use it, just, it helps you keep up your nerves but then one of the other key things that controlling your nerves, I like telling people that during moot preparation, you can always listen to a podcast or your favorite song. or just play anything in the background and it helps you, or if you like listening to like a sermon, if you're Christian, or anything that you like doing before the moot, it helps you calm down your nerves, and it's very important. And one of the other ways that you can do it is through continuous practice, that you look in the mirror, you talk to somebody. That will continuously help you deal with your nerves, and it projects your confidence. So the other way is how you even deal with your confidence is once in a while, just be in a room. Like for some of you who are students, walk into strangers and be like, I want to talk to you. They don't know what unwanted witness is about. They don't know anything about privacy law. They don't know anything about moot court, but just them your stuff, and they'll be able to receive that. The final thing is effective use of your voice, moderation, and emphasis. I think I have emphasized that the tonal variations are very important in a moot. If I am the lead agent, and I will close with this as I gave you, that your tonal variations are key. So if I'm the lead agent, I have to go on, and I'm just going to give an example, is may it please you, your excellencies. My name is Peter Ahabwe, lead agent for the state of unwanted witness. I appear, your excellencies, with my colleague Alan and my colleague Ellen. Alan, we've been accorded 30 minutes of this court's honorable time, and with me, I'll use 15 minutes to address the court on questions of jurisdiction. My colleague Alan will use 10 minutes to address the court on issues 2, and Alan will use 15 minutes to address the court on issue 3, and finally make prayers before the court. Now, when I get turned into, your excellencies, I will now turn to the facts that give rise to the matter before the court. So you need to be very, so if you're turning to something like that, don't be like, your excellencies, now, I think let's turn to the facts that give rise to the matter. Now, these facts, your excellencies, trust me, the judges will quickly just switch off. Yeah. And then when it comes to the substantive submission, if you get into, when you say, I turn now, your excellencies, to issue 1. So issue 1 concerns the right to privacy. State that with that kind of a tone of variation. And then you can do a moderation and then turn, your excellencies, as you can see, paragraph this. Paragraph 25, as has been in the decision of Justice Mulenga, like this in Uganda. Please forgive me for our international audience. I kept referring to our local jurisprudence in Uganda, but that's a list of the, I just wanted to make a little conversational. So you have to ensure that those moderations are effected as seamlessly, are gelled seamlessly into your presentation, so that the judges firstly don't get bored, they get entertained, and they keep captivated by your presentation. So I see it's 15 minutes to 3:30. I will now turn to Freda. I don't know, Freda, how we moderate this, if there are questions at this stage, or we'll take them at the end. But it's been a pleasure, and I hope that one or two ways, everyone who's been listening to me has been able to attain something from, the foundations of oral advocacy, that is understanding the moot court dynamics, the art of persuasion, the moot courtroom etiquette and professionalism, the rules of conduct, confidence, body language in advocacy. But other than that, thank you very much for listening to me. I am very glad to have been accorded this time, and I will be here to take any questions. Over to you, Freda.
Thank you so much, Peter. I really, really appreciate your submissions. The presentation has been very engaging. I want to believe that this is what every other person on the call feels, even as much as it's virtue, but you really tried to make it practical. Thank you so much, giving examples and trying to bring it home. Thank you so much, Peter. We will take questions at the end when Counsel Alan has finished making his submissions. But otherwise, for those who do not want to lose their questions, kindly use the chat room. We are on standby. We are monitoring the chat room for any questions. We will take stock of them and we will have them responded to. So at this juncture, I wish to invite Counsel Alan Manenji to please take us through the next 3 modules. It is 3:15 and hope we can be done by 4:30. If you can actually use less than that, that will be even better. Over to you, Alan. You're most welcome. Okay, as we buy time for Alan stepped off the call, so we could actually use this time to entertain some questions for Counsel Peter. If there are any clarifications that you'd want him to make, feel free to make them in the next, say, 5 minutes or so. So that as we wait for Alan to get back on the call. And then Peter, Counsel Peter, if there are also aspects that you would want to emphasize, please, you're welcome to do so. You've finished much earlier than anticipated. So if there are things that you want to emphasize, please, you're welcome to also do that as we wait for Alan to get back on the call.
All right. Thank you, Freda. I think let's by show of hands, let's have the questions. I would be very appreciative of people who said they are pretty much novice. I'm very, very open to take any questions, clarifications. I know that we are gearing up to how we'll participate, and not just participate, but compete in this moot court competition. So feel free to use to put up. Yes, Freda.
I also wanted to use this opportunity just to hint on something you did intimate at the beginning of your presentation in regard to who qualifies to participate into the competition. So for students who have previously participated in the previous editions, they do not qualify. So I am hoping that we do not have anyone who has actually participated in our own competition. Participation in other types of moot court competitions is perfectly okay. But for the one for unwanted witness, it's a rule. Once you participate in a previous edition, you don't get to join again. So I just wanted to highlight that. Over to you, Counsel Ahabwe.
All right. All right. So do we have questions? I'd be very delighted to take 1 or 2. Let's try and make this a little engaging. So I hope if I pick you up, you're okay to ask any question. I see Miriam Kente. Miriam Kente. Okay. I'm hoping she's preparing her question. All right. So for those of you who are not okay to ask directly, please use the chat. Somebody has said, what do you think about the use of opening statements? That's a nice one. This is from Stefan. I think opening statements are are very catchy ways to captivate and get the attention of the judges. But one of the key things that I usually advise about oralists, about opening statements, is that they need not to be very lengthy, right? And they need to get the point at home. So in your opening statements, usually we look at ideally about 2 or 3 things, right? Is your opening statement related to the case at hand? Is it in some way inviting the judge to have an impression, the fact that you are biasing, you know, in a good way, biasing the judge's mind? And then conclusively, in that statement, you're offering a position for your team. So it's one of the things, I don't know if Stefan have answered your question, that what do I think about them? They're great, but usually they are oralists that abuse them. Yeah. So it's very good that you use them, but they need to have that linkage to the case at hand. And I usually ask that when you're in a competition like this, you can get one of your lecturers or your team coaches to look at the at your opening statements and review them for you. They are very, very good, but they need to be used in a very carefully structured way, if I could answer. I don't know if Stefan, I have answered your question. Thank you for asking that question. All right, do we have any other question? I've been referring to Alan Hamis. Do you have a question? Alan was my teammate.
No, I don't have a question. I just like to say thank you for appreciating and mentioning me. It has been keeping me active. So thank you so much. I don't have a question. And thank you for the presentation. It was nice and good.
Thank you. Thank you very much for your kind words. Somebody has asked me, this is Angela. She's saying, is it okay to note down questions that are being asked by the judges? Just in case about 3 of them decide to ask questions at a go, so that you can recall while you're answering the questions. Yes. Angela, just to answer you, yes, it's very, very, very okay to jot down the questions. And I'll just give you this as, it's one of the things that we've been giving at SOCI. We say when you're in a moot, don't feel like you are under an obligation to appear like you didn't prepare. Let me tell you, for a matter of fact, some of you know these things more than the judges they will invite to judge you. So how you show that you actually want to engage the bench is when the question is being asked, if you have a notebook and you have a pen, for example, and that's why I said I would have preferred that this is physical, but I hope that through this demonstration and listening of my voice, you will appreciate and take this. So if I'm going to give an example. So if this is Angela asking, so if Justice, let's see the names. If Justice Eunice asked me the first question and said, what is privacy law, right? When Justice Eunice is asking, I'm writing, right? And then we go to Justice Freda. Justice Freda says, what within the facts show that the rights to privacy were violated? Right. Justice Freda. And then you go to the last one, and maybe Justice Jonathan. Yeah. Justice Jonathan is saying, what within your argument do you find persuasive that we should believe that maybe the respondents did what they could and what they did was within the law, right? That was the last question. So just to answer your question, Angela, this is how you could tactfully answer when you're writing, because when they're asking you, you demonstrate that you're writing. You just, even if you're not probably, but when you're just jotting. So the first question was privacy. That was justice, you know. You say, Your Excellencies, I will now turn to addressing your concerns. But firstly, I will begin with Justice Jonathan, or lastly, I'll begin with Justice Jonathan's question. Justice Jonathan's question intimates that what clause under the International Convention of this speaks to this? And then you answer that question, you demonstrate your knowledge, and then conclude. Then you say, I'll now turn to Justice Freda's question, which was about whether the rights, what within our facts show that the rights. Your Excellencies, paragraph 15 is very clear that this and this has been violated. And then finally, Your Excellencies, Justice, so and so. I will now answer your question on the right privacy. As earlier mentioned, I relied on a decision of Unwanted Witnesses versus Uganda, a decision of this, like that. So it's very key. And I hope, Angela, that through that. Maybe you can unmute and tell me if I've answered your question. Yeah. So that was Angela's question. Angela, have you been answered? Oh, okay, she's directly saying she's been answered. Great. This is Miguel, a guy. She's saying, what should one do when they are out of time? Yes, I already extended that you need to be cordial and you need to be respectful to the bench. So when you're out of time, don't just continue speaking, right? When you notice, when they signal, when the clerk notices and signals to you, and you're in the middle of your submission, just say, Your Excellencies or Your Lordships, I notice that my time is fast spent. Your Lordships, I had submitted or I was concluding my submission on my second header varment in regards to issue 2. I request that the bench accords me 2 more minutes to elucidate on a question that had been put to me and conclusively give my final submission in regards to issue 2. I don't know if that offers you an answer, Miguel. That is one of the tactful ways that you can address the bench, as cordial and then respectful. And that shows that you are engaging them. And one of the ways that you can even do it if let's say, again, I'm sorry to refer to our host Freda, if Justice Freda is the president of the bench, you just keep saying, respectfully, President of the bench, Justice Freda, I noticed that when you become a little personal, it gets quite engaging, and they're much likely to offer you more time. Yeah. Michelle has said, what if you do not know the answer to the question? How do you handle that? That's a very interesting one. So if you don't know, and one of the, I think the key ways is that during law school that you're told, I have not addressed my mind to that. I have not, at Soki, we don't like that question. We don't like that response. Michelle, I see your question, but please do not say, if openly that you probably generally, yeah, in a wholesome, you've not addressed your mind, you can say, Your Excellency, this is the tactful way you can say, Your Excellency, I have not addressed my mind to maybe the decision that you're referring. So I can give you an example. If they say, Unwanted Witness versus Uganda, the decision of miscellaneous one, whatever, of 2024. Justice whatever used this, then they ask you, what was if you have not addressed, you could say, Your Excellency, Justice Freda, I noticed that you're referring me to the decision of 2024. I might have not addressed my mind, but I have addressed my mind to the decision of 2025, which actually also quotes the decision that you're asking me. So in light of this, I can use my understanding, or I can expound more onto that to give an interpretation of your question or a response to your question in terms of using that case. I don't know if that offers you, Michelle, an answer, especially when you don't know the question. Yeah. So, okay. Somebody is asking, Michelle is saying, do you address the judges in the East African Court of Justice as your lordships or ladyships? I think that's homework to you, Michelle. Yeah, I will leave that to you. You can check that out. I can leave that with you. I've tried to steal some few answers for you. Okay, I am still trying to. The people who are doing direct me, so I'm reading. Okay, so that was Michelle. Michelle, I hope I've answered your question in terms of how do you answer when you don't know about how they address the judges. I'm seeing some. Okay, Freda said, Your Excellency or Her Excellency. Thank you, Freda. But please make some notes on that, Michelle. There's a question from Isa. Isa is saying, from the rules you have provided for us mooters, you assert that there shall be 30 minutes for oral arguments, 10 minutes for rebuttal, and rebuttal. Did you mean there will be 40 minutes for oral arguments and reserving 30 minutes for rebuttal? Or we should take that as you explain that in the rules? I think I can leave this to my host to answer this. If I answer, I would be taking an extra role in this. Yeah. So I'm very sure that Freda has a very, very candid response to this question. Unless we have more questions, I don't know if my colleague Alan is finally back on the call. I'm very grateful for the questions. They've been engaging. Those of you who have been able to drop in DMs, please keep them coming. I'm glad to. Oral advocacy for me is the heart of the moot. And so when you don't know particular some of the things, you will. Wonderful, wonderful. I'm glad that my colleague is back. And yes, we are going to get straight in. So over to you, Alan. I was trying to hold foot for you, but we are very ready to listen and learn from you. Over to you, Alan.
Thank you, Peter, for taking on those questions. And as Alan walks in, let's delve into what he has prepared for us. For any other questions, keep bringing them in. We have a Q&A session just after Alan's presentation. Hope, Alan, we can be done by 4:30 with you. Over to you, Alan. Thank
you. Thank you very much, Peter, for that presentation. And thank you very much for holding the fort on my behalf when I dashed out. So maybe just to confirm, can you guys see my screen? Can you hear me, and can you also see my screen?
Yes, we do. We do, okay. Alan, thank you.
Okay, that's fine. So I'm going to start by module number 3, case analysis and structuring the oral arguments. So, I mean, I'm just building up on what Peter has already said, and most of the things are the things that basically I'm going to be repeating what he said, but in a more trying to fragment each and everything. So, what I want to start with from what you were saying, want to talk about how you break down a moot problem. So obviously, I understand that the moot problem has been sent out to you guys, and you now have what you're supposed to be focusing on for this moot. The first key thing that you're supposed to do is that you're supposed to identify the key legal issues that are being raised in the moot problem. So, for example, what are the central questions of law? E.g., for example, did the government violated the subject rights to privacy under Article X? So I say Article X because, for example, I understand this mainly in East African moot. So I'm saying you obviously for each moot problem there is a legislation that the problem is trying to that you're focusing on. For example, if it says that, for example, it's a fictional country, but sometimes the question might direct you to a particular legislation that you'll be using as to benchmark with your problem. So you want to understand, we've got 5 pages. Of the 5 pages, what are the legal issues? And can the legal issues be compounded? Because that's the first thing that you want to understand, no matter if you are for the affirmative side or the defense, the prosecution, or the non-affirmative side. The issue is that you have to be able to identify that what do we want to focus on. And that then says that after you understand the legal issues, you're already distinguishing the facts from the noise. Because sometimes there are 5 pages of a moot problem, but maybe sometimes the legal issues or what you're supposed to focus on, it's not all the 5 pages, but mind you, I'm not saying you must not read, you must read all the facts, but you must understand what is that you want to focus on, and maybe do more research around that after you've identified the legal issues. And you also, like I said, you have to understand what is the jurisdiction and the applicable law. For example, this privacy moot, I haven't read the problem, the moot problem. But for example, you want to understand what is the jurisdiction that you're focusing on, and what is the applicable law of the jurisdiction. So maybe, for example, are you focusing on the East African legislation? So maybe the applicable law will be the East African if there's a particular regional piece of legislation, which also then lets you know of the applicable court that you're going to be appearing on. That then helps you to know is it the East African Court of Justice, or is it the High Court of Kenya, or are we in the High Court of of Uganda? You just have to know about that jurisdiction, and then this will also help, because these are some of the things that might not be directly be written in, sorry, of course, the jurisdiction would always be written in the moot problem, but some of the things that you need to use might not be directly being part of that problem that you want, that you'll be tackling on the day. So you want to understand like the applicable law and the jurisdiction that you are using, and then conflicting arguments. What is your side's position versus the other side's position? Anticipate the line of reasoning. So you've read the problem. You now know what are the things that you want to focus on, and obviously you know your side. That, for example, we are going to be arguing for the prosecution or for the defense, or we're going to argue for the affirmative side. But in preparing, in beginning the problem, you also have to anticipate the other side's arguments that they're going to be raising in the moot problem, so that it helps you prepare, and also that helps you come up with a stronger point. So always imagine what the opponent is going to be saying. Always imagine what works against you. So if you're trying to look in the moot problem, you're picking up the point that you want to address, but there's always that other factor or that other point that is going to work against you, that is going to be raised by the opposing team. So you need to focus on that argument, and that will also, and then you then need to structure. When you're preparing your argument, you need then to have arguments that address what the potential opposing team are going to say. And after you've done that, what are you going to do as your theme? What is the story that you want the judges to buy into? So obviously there's an issue there's an issue that's there. So the issue, obviously, the big subject matter is about privacy moot, isn't it? Then when you read the problem type question, you're going to pick, okay, first, maybe there are 4 legal issues that are being raised. So that is the issue about violation of human rights, particularly the right to privacy, or maybe that's a broader theme, or you just want to focus on a sub-theme, maybe issues about consent and giving their subjects the right to be able to protect their own privacy. So you need to build up a theme which you might not say out loud, but which judges can quickly draw from your argument as you are putting the argument across. And that theme must be consistent between the teammates. You cannot advance this particular argument and your teammate, when their time to speak, they then advance another argument, which is different from what your team would be. So building up a team helps carry the audience and the judges with you. Obviously, your team is supposed to be born from the facts that are before you. So these are the basic things that I think you must do after you identify legal issues. You distinguish the facts from the noise. Don't focus on the necessary. Most of the things that are in these problems, they are there to make you get carried away. And sometimes, although I'll get that into the other slide, the judges might also want to ask questions around the noise, but always make sure that you then bring them back in your answer to the theme that you've built up, as well as try to address the arguments being raised by the other team. So after you've broken down your argument, sorry, after that, the next stage is about how do you develop a structured argument. So there are 4 steps, therefore, there are 4 steps that I've just prepared. So we now know that you have broken down your case study, your moot problem. You now know what you have. You now know what the other part is most likely going to raise. You now understand the theme that you're working on. And then you now have to develop a roadmap, isn't it? And it's more like how you're going. It's a brief, rather, what you're going to be arguing on. So you say, you argue, I'll address 2 issues. 1, whether on the general intention law is constitutional. 2, whether the complainant's rights were breached. Under this, obviously, if you pick these 2 issues that I've picked, the theme that's coming up, it's about the breach of data protection concepts that are that are fundamental to the right to privacy. That's the theme there. So obviously in the roadmap, you have not yet gone into the main argument. You're simply letting the judges know the roadmap that you're going to be following, such that when you run out of time, you have let them know of all the points that you wanted to address. So sometimes you might not then have the time to address everything else. And use second issue that you have to use a logical flow. Keep the progression smooth, avoid jumping around. So, for example, you said that you're going to address the issue of data retention, and then the second thing you're going to address is about whether or not the rights were breached. So, obviously, what you therefore need to do is that you have to address the issue of data retention first and exhaust, and then you build up into the issues of the data subject that you breached. But you don't just go point one, point two. Each point, as you conclude the first argument, it must then introduce the second argument, so that there's a logical flow of ideas, not that you're just going to be throwing up issues around. So, for example, talk about that. I'll give an example that I didn't put on the slide. You said that data protection, the data protection law of retention is a constitutional right, and by company X, by doing this, it did breach the rights of the complainant. So obviously, if you can see, there are two arguments that I'll be talking about, but I've tried to marry the two arguments that you then try to introduce. So always link the first argument to the second argument, so that there is a logical flow of ideas. And then the third thing is that you need then to support your arguments with some authority, isn't it? And I did put the word authority there. You use statutes, precedent law, international instruments like the UDHR, Universal Declaration of Human Rights, which is where we want to talk about when the right to privacy was first introduced. You may want to talk about the GDPR. I did put the GDPR because I did not know which legal instrument you'll be focusing on, since I hadn't read your instrument. But focus on the particular legal instrument that you want. For example, if it's a moot here in the SADC, would use the SADC model law. Or if it's a moot or an Africa, because since we are all part of Africa, we know that we've got the Malabo Convention on data protection and issues. It can have the instrument that you will put. So don't, after you, of course, you've identified the legal issues, then you've put them in the roadmap, and then you're trying to make them flow. But every argument must be backed up by some authority. Is that case law? Is there a book? There are authors that are accepted in data protection. There are pages like the IAPP, including previous publications that have been produced by big companies such as the Privacy Symposium Africa, where after each and every symposium they do produce a report. So what does the report say about it's a premier event on the African continent. So always have something that supports the authority. So there is no point that must not have a supporting authority around that point. There's always somewhere where you can pick up your support. And obviously, like I said in the previous slide, you have to prepare for the battles. So you already anticipate that the opposing team, they're going to be raising this such and such a point. So you would know that in presenting your points, you're also going to then address those points before the time they're even raised by the opposing team. Then after that, I also wanted to talk about the IRAC model, which is issue, rules, application, and conclusion. So the previous slide was talking about structuring your argument in general, but this IRAC model is talking about how best you can structure each argument. So obviously, for each argument, you have to clearly state the legal question. The issue before the court is whether a man to SIM card registration without consent violates the right to data protection, as an example. Then after that, the issue that you have introduced, you want to pick up the rule or the legal position that supports your answer, and then you go according to section 5 of the and then you're going to, because you've picked up the issue, and then you're going to pick up what is the rule that applies, and then that also goes on to talk about the issue of supporting your argument. You're going to talk about, for example, you want to say, okay, is it an act, or maybe it's a judge-made law, the judicial precedent or jurisprudence, or because in the case of the court submitted this, because you're trying to say that we are not, your job as a lawyer, you are not a legislator, isn't it? Your job is to help the court interpret the law, because the court interprets the law. So your job is to take the court to where the law is, so that it can be able to interpret the law. So you pick up the legal issue there. The second thing is you're going to say, why is the legal issue? Where is the rule? Where is the authority to support that legal issue? Then after that, you're going to talk about the application. You have to apply the fact to the question. And the issue there is that did or not did it not was there SIM card replacement without the consent? So in this case, the subject was not informed, or which contradicts the consent requirement section of, or in this case, Mr. Manenji by illegally registering the SIM card of Miss Freda. She did so breach his right to data protection. So yeah, you picked up the issue, you've taken the issue where the law is found, and then you're going to extract from the problem type question the particular paragraph or line that speaks to the issue and that you've read, so that we show that there was a violation of the right there. Then after that, you then end with a persuasive summary. And therefore, we respectfully submit that the law violates the right to privacy and should be declared unconstitutional. Or then, because we therefore respectfully submit that because SIM cards were registered but without the consent of the data subject, so A, B, C, D. As you can see, that way you are trying your best to apply the IRAC module. So the IRAC module is always about pick up the issue first that you want to talk about, then go and find, where do we find the law? What is the applicable law? Is there judgment law? Is there a conference report? What is the authority that is acceptable? So the issue there is that you have to follow the hierarchy of the laws that are applicable. Or start from the constitution or the international instruments that are applicable or that are domesticated in our countries, until we go to the last source, which is the authorities, like the authors who are also persuasive. So this is how you then focus on your IRAC method. So when using the IRAC method, avoid reciting it rhetorically. Make it a conversation and engaging. Like I was talking about earlier on about using the transitional phases. Now let me address the legal, the transitional phases. So you are not just going to say this is the issue, this is the law, like the way I was presenting it. It has to be a conversation, it has to be engaging. Each last sentence must feed into the next. So the first step you want to talk about the issue. The last sentence that you're talking about the issue must feed into the rule that you want to refer to. Now, let me now address the relevant legal rule or the relevant legal question, or according to section that this was that, and then you're trying to build up so that there's a natural flow, and then you must stay concise. Judges can lose interest if you're too long and winded, and yourself might end up contradicting yourself. So just try to be short and concise, and try to just limit yourself to what you want to talk about, and always echo your statements to the facts and the law. So follow the 4 steps that we talked about: the issue, the rule, application, and the conclusion, but not in a robotical manner. Let's use transitional phases that helps you link the issues that you'll be talking about. So that will be what I had under module 3. And then I can move on and then just say the Q&A later on, isn't it? So we want to talk about module 4, handling judicial interventions and question and answer. So our legal systems usually vary, but when you're in a moot system, you must always appreciate that you are using the acquisitorial judicial system, whereby the judge is always allowed to ask, to intervene and ask if they've got any questions. And I think the technique there is to test your stamina, is to test your ability to withstand pressure. So what you need to do, you are a lawyer. I know you are still law students, but you are lawyers, of tomorrow. You ought to be a person who's able to think on their feet. So sometimes you may prepare an argument, and the judge might just throw in a question of something that you're not anticipating. You must quickly be able to think about it. For example, I'll give an example. When I was in high school, I was in a debate, not a moot, but this example applies. I was in a debate and I think the topic there had something to do with religion, and with this just academic. Please, no one should take offense from me. and we're just talking about how religion is oppressive to people, and it's oppressive to people. And the judge they asked me if I was a Christian, and of course, and with respect to everyone else as well, I'm a Christian, and I don't look down upon other faith. And then I said no in that question. I'm a Muslim, and because the Islamic culture allows for polygamous, and because my mom was a young wife, I was then forced to join the Islamic religion. Of course, that way but my point was to say that religion is oppressive. So when they asked me to, am I a Christian, they were wanted to say that how was I forced, to be into religion. Then I thought of a religion that I thought, without prejudice, and also I was young, not that it reflects the core values of the religion today. So your ability to think off your feet and to be able to quickly answer a question and to maintain your thematic and the flow of your argument is very critical. So I just want to look at the type of other questions that judges ask. Judges can ask a question when they want to simply seek clarification. It's about just them wanting to understand. Possibly you've said something that them as judges, when they read the problem question, they not anticipated. So they want to seek clarification. They want to know what is the argument that you're coming up with. Or they can ask hypothetical questions that are going to test the scope of your reasoning, like the ones I was just giving just now. Because also there are points that, depending on the score sheet, they want just someone who's able to bring out well thought out arguments, and that you should have a clear and a good reasoning. And the judges want to challenge your legal basis or your assumptions. It's a pushback, it's a technique, but it's also the issue there's that sometimes when moots are national moots like this, after the report is produced, you may even spark a debate in the national in the National Assembly. You may influence policy through a moot, if so to speak. So judges are there to challenge your legal basis, your assumptions, so that your inner thoughts, or you think outside the box and bring out sometimes most of the time the biggest argument will come up when the time that you didn't prepare for. It will come up during the time that you're thinking off your feet, or especially the time that you think, oh my God, what am I going to say? Because you are not sure of the answer that you want to say. Sometimes your mind is very creative and you end up saying a very good thought. So here's the thing, the tip is that don't panic during judicial intervention. It's normal. Take a breath before responding to the question. It's always normal. Just know that, okay, expect it that they're going to intervene. So expect it, and then mark that you're talking about this point, address their intervention, and then so always just so the thing is that you should acknowledge the question. That's a valid concern, your lordship. Then pivot off to your response. Oh, thank you very much for that question. Then you go ahead and talk about the response that they wanted, the response that they are looking out from you. And in that response, again, it must then quickly lead you into your next point. So you have to have that ability that you are not anticipating to give that response, because it's not part of what you've prepared for, because it's just coming as a judicial intervention. But now, the last sentence to your response must quickly then lead you into the next point that you want to talk about. Also, sometimes you might end up rearranging the ideas quickly. So because what the question that they've asked you is leading you to a particular topic, or to a particular theme, or to a particular argument that you're going to raise maybe later on. Or if you had already raised the argument, you then conclude and then introduce the other argument. So for you to be able to quickly respond very well to questions, because I'm sure there are points for addressing questions very carefully. You must always listen actively. Do not interrupt. Give them a chance to ask you, and even if what they're asking you is what you said, you listen and you wait for them to finish the question there. So you wait. They are trying. So sometimes I know you'll be eager to then respond to yourself, or sometimes they may throw in words that you would not have said, but you are patient enough. You just wait for them so that you interrupt them, and then you clarify the question if you need to, not all the time. If I understand your question, your lordship, correctly, then you go on to repeat the question they've said, or you say that, okay, unfortunately I noted that point, but you have let them finish first. Then after that, you're going to clarify the question, or maybe you then, even if you identified that, always try to clarify. So it's not always that you need to clarify the question. You need to clarify the question when they need to do so, and then answer directly, then explain. So the issue there is that what I mean is that they say that did the government for example, the question would be, cancel. In other words, are you saying that because the SIM card were registered without consent, it constituted violation of data protection laws? Your answer is going to be directly yes. By failing to seek consent, they did constitute the violate data protection laws. Then full stop. Then you go on. You try to explain. I say so, or we submit so because there's a law like this, which is the like this, or the judge, that kind of thing. So the first thing is you always have to answer the question first before you explain, because when you answer the question, when you explain, your answer might not mean anything to them. So answer the question first and then go ahead to explain. If you don't know the answer, you said, oh, I'll address that shortly, or I'll be able to respond that in my rebuttal, so that you can you can avoid answering the question, or you can defer to your colleague if you're in a team. It's always depending on the rules. I'm not sure, but in a team, you can always refer to your colleague. I will let my colleague answer that, but let your colleague give you the signal that they are able to let your colleague give you the signal that they're able to answer that question. So always look about that. Memorial integration. So always use your memorials integration as a guide, not a script. You have submitted memorials, and your memorials are always there to guide your arguments, where you want the argument to take you to, and they are not a script that you want to try and regurgitate. You want to try and bring a new, fresh perspective to your memorials, and quote key statutes, arguments to support your spoken arguments. So obviously in the memorials, because you prepared them thoroughly. I think most of the people who judge most, they will tell you that memorials are always, if you have a good team, that you've done very good memorials. So from the memorials, either for you regarding them, you can quote some of the statutes of the judgments that you've reported and referred to in the memorials to support your spoken argument, and avoid reading. You must paraphrase legal authorities confidently, and use memorial headings to structure your oral arguments. So instead of you just reading out, for example, if you're putting some headings in the memorial argument, you can use that to pick up and then structure your oral, so that your argument, your oral argument, and your memorials, they speak in tandem. But the question there is that you must not use them as a guide, or you must not read your memorials. You must, you must use them as a guide. They need to script. You want an exciting mood. You want the audience to enjoy. You want the judges to enjoy. Most the chances are very either the judges have already read your memorials, so don't make them feel bored by them listening to what they've already read and adjudicated on already. So obviously there's issues of consistency. So you might find that because memorials are submitted way earlier than the day that the oral arguments are made, there might be discrepancy that may arise between the oral and the written arguments. So you can handle this in two ways. Always clarify updates in position. So sometimes, depending on if the inconsistency is so glaring, you can also start by saying, in our memorials, we submitted this point, but after this has happened, or maybe, for example, the Malabo Convention came into force in June of 2024. But if you prepared your memorials in May, the Malabo Convention was not yet effective because it had not had the 15th state signing off. So now you're doing your oral arguments in September. You tell them, at the time of submitting our memorials, the Malabo Convention was not yet effective or not active because of the. But as of 23 June, the convention is now effective because the 33rd state has done A, B, C, D, and then you are picking up. And then you then need to reinforce your oral argument that reflects a recent or better analysis, because obviously you've had more time to prepare and to read around to prepare for the moot. And I understand that judge respect acceptability, not inconsistency. So you must just stay coherent. So always take a proactive approach to control the narrative. You must control the narrative so that you don't you avoid the judges picking up that in a moment they said this, or avoid that the team saying that in their memorials this was said, because the portion will be changed. It's possible that the portion can change, especially when you're looking at international instruments whereby there are changes that can happen. So I think module number 4 was very short. So I want to move on to module number 5, which will be the last module. But maybe for now, I can quickly address some few questions if there are any. Then I can move. I can move on. I understand that's about 30 minutes. We're doing very well on time. So let me stop sharing the screen so that I can. Okay, all right. Any questions from what you've said so far, or I can quickly proceed, because I'm sure it will be able to be done by 4:15 your time. My module number 5 is not as big either. I hope I was talking to some people because the silence is alarming. Okay, I'll move on to module number 5, but before that, can I just get a nod if people are hearing me for the past 30 minutes that I've been speaking?
We can hear you.
Okay, thank you very much. Thank you very much, Sandy Lauren, for responding. So we'll move on quickly to module number 5. So module number 5 talks about litigation techniques and advancing the advocacy skills. So this slide explains that a litigation mastery in the moot court arena. So you are in the chief focus. I want to say that you should elevate your own advocacy with real world litigation techniques. So you must need to decongest your mind to just think that, look, what I'm doing here, I'm simply in a moot court. It's not a real court and stuff. You need to picture yourself as if you're in a real court, a real world court room, and also adopt the real world litigation techniques. And when there are times that you can also try to go visit a local court in your area and listen to the advocates in those areas speak, including even a small court, you may pick a technique that you may also want to then adopt that can also help you elevate your litigation techniques. And you need to learn how to rebut arguments with authority and confidence. Even when someone raises a very strong point against you, always try to to build up your arguments with authority, and then you need to explore the psychological aspects of persuasion. So again, the 3 things that I'm going to be focusing on in this module, and this module will transform good mooters into great litigators. It is it's about sharp thinking, sharp delivery, and the sharp message. So let's see what the module is for us in stock. The first thing is that responding to opposing counsel. So we talked about earlier on how you respond to a judge, but now how do you respond in opposing counsel, especially if there's chance that you guys can interact or respond to them in your respond to them in your what do you call this? Respond to them in your cross-examination or in your rebuttals or in your other arguments. So you must always listen carefully to opposing counsel's submission. Don't focus so much on other things when your opponent is speaking, because when they speak, that's the time that they're most likely going to raise an argument that is going to work against you. So identify the core thesis of their argument. Don't be distracted by minor errors or go for the jugular. They may come and throw big words, in their arguments, but as a good debater, as a good motor, do not try and focus so much on their errors that they've made or on their big words. Try to understand the thesis of their argument or the theme. So remember, in the module number 3, I encourage you that you come up with a theme as you're developing your argument. So yes, the opposing counsel, then you must understand what is their theme, and then try to respond directly. You also have to let them know that the opposing counsel has argued that the consent was implied, but however, so you've understood their thesis, so you obviously want to dismantle that theme so that your theme that you've established yourself remains one. So remember, it's also I've had to adjudicate some moots before. There are times whereby even as an adjudicator, you don't have seen the other argument, the other side of the argument that's being raised. So sometimes a team might come and raise a point which will make you to believe. But if someone then comes and tries to dismantle that point, it also invokes that critical thinking in the mind of the adjudicator, so the adjudicator can still stay in your lane and can still try to be favorable. Can still try to be favorable in your arguments. So avoid attacks on the other counsel and stay professional, isn't it? So we respectfully disagree is more effective than combative. So say that the opposing counsel really shows no logic, or I'm just trying to think of what we used to do back then. But it's always that you're in a courtroom. You are learned colleagues. You are friends. Remember, it's a client's case. It's not yours. So even if the other person says something that you do not agree with, even if you've got that push at heart, at the time that you're making the argument, you're not speaking on your behalf. It's a client's case. It's not your case. So you must always, therefore, respond with grace and with respect, rather than to try to be combative or try to make sure that they see that the opposite. So it will be that class and poise that will help you stand out as a professional motor, which will be appreciated rather than someone who's just trying to fight the opposing counsel. So write key points of their submission on a paper or note card during their presentation for you to rebut. Please, you are under pressure. You cannot just think that you're going to rebut. Even if the point that they've talked about was part of a paper that you have, prepare another little paper that you cross-check after you have done your rebuttal, that if you addressed each point in the rebuttal, because sometimes you might think you're going to address at that point, but because you have already prepared it with some cue cards, you might not address it the way that you want. So if you have taken down the point that they've raised, it gives you the room to then correctly then be able to address the point in rebuttal. So how do you disclaim the weak claims? Breaking arguments without breaking your composure. I was just trying to borrow some quotations from the source that I was consulting. Focus on the logical structure of the argument. Are there any gaps? Isn't it? So now they've said the argument which you think it's weak, or the argument that they have, but you forced to think is that, are there any gaps that they've skipped? Well, sometimes also because we want to advance an argument, you tend sometimes to skip some relevant information and only focus on your own argument. So you're going to think, are there any gap? E.g., they skipped application of the rule to the text, or point out that out to the, that in a respectful manner, so that you can advance your argument, and then you must use legal authority to contradict them. Don't just say that the opposing counsel with respect was not being truthful and stuff. What is it that you can use to contradict them? So it's in the case that you always find the racial disdain behind a judgment, or the obiter that you can use. For example, in the case of Unwanted Witness, the means of ICT, the courtroom that consent must be informed and active. So that when you said that, and then you go on to dismantle, or that the opposing counsel was not truthful because in the case, no. So you're trying just to use some authority. Let there be legal authority. Is it a case law? Is it a statute law? Is it an international instrument that you can that you can use, and also always introduce counterfactuals. So they have introduced a standpoint that they were talking about. So you now use your counterfactual to say that even if that interpretation was to be accepted, it's too false, and so that the judge can say that in his mind they have said this, but their argument is weak, and remember, because remember, at the end of the day, you are fighting for the judge to see your argument as the best argument of the day. So you need then to say what you now need to use their arguments against them, so that you make your theme and your argument that you are pursuing to be the one that will be the true one and to be accepted. And then you should repeat the core of their argument before debating it. It shows that you listened and you build some ethos around. So always try to repeat, but try to all this. Remember, you time on your side. So when I'm saying repeat the core of the argument, the prosecution argue that consent is not a legal requirement. So obviously they would not have said in such a way. They'll say in many ways, but because they simply want to focus on that little aspect, just try to repeat the core of the argument in a sentence, in a few words, and then you go on to build up a rebuttal by focusing on the logical structure, using legal authority, and to then introduce your counterfactuals. So under counter arguments and rebuttal structure is that hit back with precision, building the perfect rebuttal. For example, the structure is that acknowledge the opposing views. My learned friend has submitted this, and then like what you said in the last, always try to you effectively acknowledge what they have said, because it's something that they've said. When you acknowledge, it helps that when it's time for you to then rebut, you are rebutting a point that you've already said, that you then to know. It also helps the judges to know which particular point are you rebutting, because if the judges are taking some notes, if you just start by trying to rebut a same point without repeating, acknowledge that view, it means that there is no coherence between your ideas. Then you have to refute the law, the facts. You say that my learning friends submitted this A, B, C, but however, the and regulation clearly state that, and then you've after their view, you've refuted that view with some law, with some fact, or with some authority, and then you therefore you therefore go on to reinforce your position, because it's a rebuttal. So you pick up their point, refute the point, and reinforce your position. So therefore, our position still remains that this was a breach of privacy. And then by that you say it's a position that you keep softly, use polite, but you use polite language. Keep softly. Don't try to use aggressive language that much. People with this that in court, lawyers are there to undermine each other to show that you are someone better than you. Of course, you are better. You want to be better than them, but be better than them by using the correct approach and techniques, having the better argument, having the good arguments, having some grace and some class around it. And with respect that the argument, the example gave that with respect that argument overlooks jurisprudence from both our jurisdictions and comparative views. So that would be the way you rebut. So you acknowledge their point first, you refute that with the law, then you go on to reinforce your position. So that at the end of the day, this also provides a comparison in the two arguments that you talked about their point, you feel that you want to talk about, you reinforce your argument. So already in the mind of the adjudicator, there's a comparison between the point that they raised and your point. But in your advantage now is that because you have refuted that with the law, your argument is too stronger because you've got the law and the reinforced position that you've talked about, which will be there. And always use polite and point rephrasing so that you avoid being combative. So if you are going to, if the moot is going to have cross-examination start in some cross-examination or in some rebut, but I said someone didn't say that think like a litigator but speak like a moot star. So they use rhetorical questions to sow doubt. You know, you even if when you start, you know, you can just throw a rhetorical question that you want to show that can consent be truly be implied when the user was informed, either notified, then you end there. This is not a question that you want a response to, but it's there to invoke some thinking in the head of the judges there, so that they can see things from your perspective, not from the perspective of your colleague. And then if you're going to do cross-examination again, you need to highlight inconsistencies in other teams' memorial versus their oral argument. So like I said that, to the time I was saying that earlier on the side of memorials, that sometimes they might be inconsistent. So control the narrative, acknowledge the inconsistency yourself. Otherwise, you also need them to highlight inconsistency that in other teams' memorials, so that in that they said this, include even if you know the reason why they were inconsistent. For example, I give the example of the Malabo Convention, that in June 2023, that's when it was ratified. So if the memorials were prepared in May, obviously those memorials would have talked about not having adequate memorials. So obviously pick it up, then you know that after September, during the oral arguments, it was actually in June. So you know the reason why those members are inaccurate is because at the time that they wrote, the law was not yet effective. But it's not your case to pick it up that the opposing team is submitted this, but surprisingly in their own thing. Because if they don't take to control the narrative, use that to your advantage, it also shows that lack of preparation on their part, because where memorials and oral arguments speak to each other, there's a challenge there, isn't it? And bring out the conditions gently. Don't look like you are attacking. So I gave an example there, and it says that if the law does not require express consent as they claim, then why does Section 8 include a provision for opt-in data collection? As you can see, the way some of there, it's giving out to also just invoke a sense of critical thinking in the audience, including your teammates. You may even disorient your own teammates by just putting the rhetorical questions, contradicting, using the witful manner of speaking, like I just said in that other slide. So the psychology of advocacy, I'm sure I'm just going to read through this. I wouldn't want to go into Peter's presentation. I just prepared as part of my presentation, but the issue there, it's not just the law, it's persuasion. So you may know the law, isn't it? You may know the law, but are you persuading the judges that are sitting there? So for example, credibility is currency. Be accurate, honest, and respectful. So sometimes students tend to throw in a case that they think the judge doesn't know, but because you don't know the day-to-day practice of the person sitting in front of you, and they might have done their research, or sometimes you might try to twist some facts of a problem that you want to reply to rely on to advantage, which will not help you in any way. Use logical framing and emotional hooks. You know, example there, this is not just about compliance, it's about putting the vulnerable that subject from exploitation. So that's an emotional hook. When you talk about someone being vulnerable, the judge that's sitting there is not going to think about a big tech guy in a corner office in the city. Going to think about someone in the remote village there who needs protection, because you're talking about how vulnerable does happen. Even if the violation occurred in a tech company, if they can do this in tech companies, what about the people that are in the raw parts of Uganda or Tanzania or Kenya, to speak about that? So emphasize the human impact. Judges are more likely to remember the case where the right is explained in right terms. So emphasize the human impact. So there are human beings that are adjudicating. So they want to understand that emotional philosophy in your argument, put that human impact, so that they understand where there are no So you use your emotive tools, for example, repetition, no notice, no consent, no justice. Already the issue that you're talking about there, you're simply trying to speak about the whole issue of if consent was not collected. It's not about the compliance issue, it's about the vulnerable. So you're just saying that when the needed the consent there was not just served. At the end of the day, you are trying to be emotive about the way you are doing that and refer to the affected party's plight. Make the judge see make the judges see that the plight of the affected party, make them see if or maybe make them imagine if they were to be in the other person's hands. So the tone must vary, the pitch, then pause for effect and stress emotionally charged words, the vulnerable, the subject, you stress them, the effect, no notice, no consent, always use the tone that is valid, that will always bring out what you want it to be. You want them to know the effect of them not doing something. You also want them to know or to understand the emotionally charged words. So delivering a memorable closing, make your last words counter. That is so the first thing that you have to return to your theme. What was the thing that you're working about, and then use a signposting technique. Let me leave this bench with 3 reasons to decide in our favor, and then you pick up the best 3 arguments or the best thing that has happened. For example, you might want to be emotive. You're just going to pick up something that I don't know the judge is going to say, oh, because of this, we cannot row against their favor. And with a call to action in a world that defines dignity, this court is a duty to safeguard both. So you are simply just trying to, so it's your closing argument. It's all about you trying to be as creative. You've changed your theme. You signposting that, that kind of thing. You are drawing the judges to speak or to rule in your favor or to speak from your own eye. And for example, your lordship, the right to private is not a luxury; it's a line in the sand. And I was just picking up some things that I was seeing on the internet that I thought might be exciting there. So always make sure you use that in a call to action, use signposting technique, and always make sure that you listen to your theme, because at the end of the day, they must know what you want to talk about and what your theme was all about. So I'd come up with an activity there, but I'll send the slides, something that you can always do on your own is practice. So I'll skip that slide. So that is what I had prepared for now. The last 2 slides are on an activity. You can always focus on that. So maybe for now, I can start to deal with the questions there.
Thank you, Alan, for that elaborate presentation. Our dear participants, do we have any questions for our esteemed facilitators today? Do we have any questions? Yes. Okay, as we wait for more, okay, someone is saying, would polite, okay. There is a question in the chat room. And to Alan and Peter, you could take it up. There is a question that says, would polite, this word, butter suffice? The question is, would polite banter suffice as combativeness during counter arguments?
Well, the question, the issue there is that you've used the word polite polite banter. So it could it should work in your favor, but don't try depending on the banter itself, because you may think you're being polite, but you're not as polite. So I think for me it works here and there. You also need just to throw in a little bit of banter so that you just excite the audience, but not try to keep it on the minimum so that it's also very respectful to the other parties.
Thank you, Alan. I also have a question made in during the previous session. So from the rules you have, okay, this was made by Issa Matandika. From the rules you have provided for us as voters, you assert that there shall be 30 minutes for oral arguments and 10 minutes for rebuttal and sub-rebuttal. Did you mean there will be 40 minutes for arguments and reserving some minutes for rebuttal, or we should take as the way you explained the rules?
So Freda, you're breaking up. I can't hear you anymore.
No, what this question was, it is actually meant for us in the rules. The question is, from the rules you have provided for us as voters, you assert that there shall be 30 minutes for oral arguments and 10 minutes for rebuttal and sub-rebuttal. Did you mean there will be 40 minutes for arguments and reserving some minutes for rebuttal, or we should take as the way you explained in the rules? This question is coming from Issa Matandika. Issa, and to the rest, I just want to clarify, for every either applicant or respondent, you have 30 minutes. So which means there's an hour for you to have made your submissions and your co-counsels. So you obviously divide the 30 minutes, you apportion it in terms of the issues you want to address. You have to obviously plan for your opening statements, your introduction, your presentation or presentation of yourselves or introduction to the bench. So all that you have to plan within the 30 minutes as either applicant or respondent. And once the 1 hour has elapsed, then there will be additional 10 minutes for rebuttal and any other questions that may arise either from the bench or clarifications that they need to that need to be made. But obviously, our able facilitators have also advised you that in the event that, say, your time elapses, so the 1 hour and probably 10 minutes elapses, so which means that if we are to also still divide the 10 minutes, so that means each side has 5-5, right? But if it elapses, you can politely indulge the bench and request. If you're aware of who is leading the bench, then and depending on which court you're appearing before, then you would request. You'd request for maybe an extra 2 minutes, extra 5 minutes for you to wrap up your submissions. So, and then see whether they would actually grant it. Because don't proceed without you making this request, because sometimes at the bench they will even tell you, the judges will tell you, oh, your time has elapsed, So you can take your risk and request. But obviously, as a good advocate, make sure that you make use of that time that you've been allocated. Don't forget that this is a competition, but also in real life, you will have estimated time for you to be heard and to make submissions. So make sure that you prepare in a way that you are able to submit within the time that is given. I don't know if there are any more questions. Okay, sometimes questions, okay. Someone is saying, Musonera, sometimes questions from a judge may sound not so relevant. At least I had this one of the competitions that Innocent attended. What advice can you give to our mooters on how to handle that if at all it does happen? Peter, are you there?
Yes, yes, Freda, I'm here.
Yes, I would like you to take up that question. Thank you.
What was the question? I beg your pardon.
Okay, so the question is from Musonera. Sometimes questions from a judge may sound not so relevant. At least I had this one of the competitions I attended. What advice can be given to our mooters on how to handle that if it does happen?
Yeah, so and I want to take this broadly just to answer you. So firstly, some questions I'm not majorly. Okay, you will find that a cross-cutting number of the questions are meant to guide you. But if you find a question that is meant to take you off the hook, one of the first ways is not to sort of make the judge look like he asked the most stupid question. No, it's for you to actually try and use it as an advantage to prepare either something that you didn't emphasize. So if the judge asks you something that maybe is not related, you can actually just politely say, Your Excellency, I noticed maybe your question requires me to explain or underscore this interpretation of this provision or in this kind of an angle. And then while you do that, you go around that and then get back to the gist of something that you particularly want to address. And if you find a plethora of those questions, it's very key that you do not take so much of your time in deliberating as an answer or as a response. But oftentimes you'll find that most of the questions are meant to guide you, really, generally. But then there are also a host of those that you receive and they are just meant to push you. But tactfully, just as a response, one of the ways you can just answer is, Your Excellency, I see your question requires me to answer like this. My understanding to this is to this end, and you stop there. But then don't forget where you had stopped, and then gel that submission back to where you had stopped, and then conclude your submission. It's one of the tactful ways you can deal with, for lack of a better word, a very non-contributing and disengaging question. Yeah.
Thank you, Peter. And just to also say that some of the questions are really meant to throw you off balance. Sometimes they are testing to see whether you're able to be distracted and at the same time be able to continue with what you were saying. And like Peter says, be able to pick up immediately from where you stopped and conclude your submission. There's another question in relation to the rules. There's somewhere written that only 2 people are allowed per team, but during the registration, we had a slot for the researcher. How is it going to play out? Are all the 3 members supposed to vote? So a team is made up of 3 people. And of the 3, we have 2 are mooters. We have a first mooter and a second mooter. These were aspects that were supposed to be properly clarified during your registration. So we have indication of in each team who is the first mooter and who is the second mooter. The third person is your coach. Is your coach or your coordinator or any senior person that has been designated to support you As unwanted witness, we believe that teams need to continue with someone who is senior to support them in the preparations all the way. And as you progress into the competition, depending on what level, your coach is around to support you as you continue to prepare to ensure that you actually make it to the final rounds. I hope with this, I have answered your question. I think it was from Michelle Ratemo. Do we have any other questions? Any questions? Okay. To our esteemed facilitators, I want to thank you so much. And as we draw to a close of this moot, Peter, could you give your last parting words as a finalization? Some few tips, a word of wisdom that you'd want to give to the mooters, and in the next 2 minutes, and then when you're done, then we can also hear from Alan, his word of wisdom before I come in at the end. Councillor Peter, you're welcome.
Thank you. Sorry, I'm just going through the chat. So somebody had just said, this is Alan, and she's saying, my apology, I beg your pardon on the last answer in response to Michelle's question. Freda, could you answer that maybe before? Freda, are you able to hear me?
Yes, Peter, I will do that when I am making the final closing remarks.
So, so sorry. So my parting shots, firstly, I want to extend a hearty thank you to the team Unwanted Witness. You're doing such an impeccable job by tooling the next court bulldozers and world-class litigants that we expect out there. So thank you very much for this opportunity that you're availing mooters. Like I already say, you're the only, I think, moot court competition that I know that uniquely organizes something like this. So kudos to you. To the mooters and the participants, you only have 30 minutes, and 30 minutes can change you from just something you've been, taking for granted to something that you could use for the rest of your life. So here's the word: practice, practice. It only gets better. Use everything that you've had here. Advance yourself from just being ordinary to extraordinary and to, to excellent. It only gets better and better. So use every opportunity that you will have between now until the D-Day of the moot to just keep practicing and keep, advancing. You're definitely going to shock yourself. But I wish you the very best, and I hope that everything we've shared here has in some way been resourceful and been of value addition. Thank you very much to the team Unwanted Witness. Back to you, Freda. Thank you and God bless.
Thank you, Peter. Alan, you're most welcome to make your parting shots.
Thank you very much, Freda. Thank you very much, team, for listening. I'll be available. You can connect with me via LinkedIn if you want to chat more or hear my opinions on privacy. I'll really be happy to do that if it's allowed with the rules, of course. And just to say that, like what Peter said, there's only way you can make it is to succeed. Is to practice. So you need to practice and you need to read wide. So sometimes you may have a position of the law in your statute and you're just going to read the act, you've picked up the problem there. But maybe the problem is about consent. You need to read wide about consent, such that when you're making arguments, it comes naturally. you tend to be good in answering questions about an area that you know too well. You don't know how to answer a question of area that you don't know. So in as much as you might have done that portion as a course in school, but read wide around the issues that you want to debate on or that you want to argue on in your moot. So if you read wide, you've got the knowledge base in your fingertips, it will be easy for you to be able to make that argument. And just know that whoever, even if it's your first time mooting and you're mooting against someone who's mooted against 10 times, it doesn't matter, okay? Because you are the best that's sitting in that chair, and you can still be the best in as much money is always one. The reason why that there are many people with titles in different disciplines is that there's always someone who needs to rise up to the occasion. So if it's your first time here, please, there's nothing to be worried about. Rise up to the occasion and make it count on your behalf. And I'm wishing you all the best to all the participants, and may the best men win. Thank you, Freda.
Thank you, Alan, for those good words of wisdom. I hope our esteemed mooting teams are taking notes. So as we come to a close with our bootcamp, first of all, I want to thank you so much for being, for first of all, braving and being resilient to attend since we started on Tuesday, especially for those who have attended since Tuesday, because we should be even more than this. We should be close to 90 because we have the teams are composed of 3 people. But nonetheless, thank you. We want to also thank our esteemed facilitators, all those that have supported the initial sessions up until today, where we have heard from Alan and Peter. So the question on still team composition, this was coming from Alan. Alan and the rest who need clarification, like I earlier intimated that the team is composed of 3. Of the 3, we have 2 mooters, the first mooter and second mooter, and the third person is usually in the status of either a lecturer, a designated coordinator, or a coach who is meant to continue to support the team in the preparations for this competition. From obviously when you have to prepare memorials up until when you get to the stage of making your oral submissions in September. So your coach, your coordinator, your name it, the person who has been designated is usually of senior ranking, and this person is there to help you prepare and support you in every way that you need to be supported to make sure that you are the winning team. Okay. As I close, I want to emphasize 1 or 2, 3 things. First of all, please, I can't emphasize enough the rules of the competition. Please, this is your Bible, this is your Quran for the next few months until we actually get to the last phase of the competition. Up until 25th September, the rules are your Bible and Quran. Please revisit them to be able to ensure that you're compliant in terms of your written memorials, compliant in terms of your oral presentation, your dressing code. We speak about all these things. Council Peter did share with you that it's for us in this competition, we usually want the mooters to rob. So please prepare to rob. We want the experience to be as you have finished your studies and you're out there and you've started practicing. So even if it is a simulation, even if it's a moot, but we want that experience to also be extended in the way you present. So we don't want a situation where we only just talk about we don't want to talk about a situation where people, we just tell you, oh, you're supposed to dress like this. You're supposed to do this. We want you to actually do it. So in the Unwanted Witness Privacy Moot court competition, for us, it's hands-on. It's everything. Everything you know about court is actually, we try to make sure that it is felt, it is part of the experience. Obviously, you know the colors that usually as we lawyers we put on. They are usually dull, so you will not come with a red or a shouting or turquoise green, or you will not do such thing. Our colors are very subtle as lawyers generally, gray, black, with white shirts. That kind of a thing. The colors should be subtle. Navy blue, usually those are the common ones we use. Black, obviously black, you can't go wrong. But gray, navy blue, those are the things that we play around with a lot. But definitely please rob, because even the judges who are going to adjudicate at the different rounds, they will be robbed as well. They will rob, because the robes, these robes you have, and these robes they do also have them on them. So I hope I've answered that, because I saw a question that was coming in on that. So so the person asking about blue, it should be navy blue, not any kind of blue, not sky blue, not what. It should be navy blue, because navy blue is dark. It is subtle. So let's leave that. The issue of the presentations made during the competition, during the boot camp, will be shared with you, and we will provide a link where you can actually access. You need to give us some time to organize them properly for each boot camp, each session, and then we will share with you via a link, and you'll be able to access these presentations as our resourceful facilitators provided during the sessions. Having emphasized the rules, I hope by now everyone has downloaded a copy for themselves via our website, www.uwmoot.com. Please, if you haven't done so, please do. Now that the boot camps have been completed as of today, I want to flag you off to start preparing your memorials. Ladies and gentlemen, your memorials are very, very important. In this time around, unlike any other edition that we've held, the memorials this time around are your ticket to qualifying for the national rounds. And it is just not your memorial, but you must appear in the first top 4 marks, because after marking them, they are going to be graded from the 1st to the 4th with the top marks in every country. Those are the ones that will qualify for the national rounds. It has been quite different in the past that you you had to prepare your memorials, but you would still proceed to the next round. But this time around, your ticket to the national rounds is your memorial. So please, your memorial is very, very important. Your memorial is as important as your oral presentations that you'll be making in September. So pay attention when you're preparing it. Make sure that it is in line with the rules. Don't allow yourself to miss marks or get marks to be deducted over flimsy aspects. If we say it's 10 pages, please, they are colored coded pages for a memorial that you present either as applicant or respondent, please do so. If we've said do not put your university names, your unique identifier number or code that you were allocated in your acceptance letter, once you put your university, you're going to be penalized. So don't lose marks in such a way, okay? Don't allow yourself, because such aspects should be the easiest way to make marks, okay? Don't forget it's a competition, but also this is to remind you that even out there when you're practicing, there are certain rules that we follow as lawyers, either whether we are in court, whether we are preparing a legal document, there are certain parameters, there are certain criteria that we follow, and you cannot change them, okay? Because that is what it is. That is how our profession is largely, okay? I would like to emphasize these particular dates. We are progressing slowly into the moot itself. And as I've said, please start preparing your memorials. The deadline for submission of the memorials is on Friday, 27th June. So you will submit on that day or before 23:59 hours. Any late submissions will not be allowed. The deadline for marking the written memorials will be on Friday, 25th July, on or before 23:59 hours. Notification to teams about their penalty scores will be on Monday, 18th August, or before 23:59 hours. The deadline for any written appeals against the decision to impose penalties should be submitted on 29th August. The announcement for releasing of final written memorial results of the qualifying teams that will proceed to the national rounds will be on 3rd September. Ladies and gentlemen, any changes to your team compositions from what was shared during registration should be done on or before 23:59 hours on Friday, 5th September 2025. Lastly, I want to draw your attention that just before we commence the national rounds in the respective countries, there will be a pre-moot conference or a pre-convening where we will have an interface with industry experts, academic researchers, that it's a platform that brings all these players in the industry, and you will have an opportunity to engage with them. There will be a paper, a policy paper on the digital national ID systems in East Africa that will inform and set the stage for the discussions or during that pre-moot conference on the 8th. Your participation up until that date will be virtually. We will send you a link for you to participate. It is imperative, and I repeat, it is imperative that you do attend, because this is going to still help you as you kick off your national rounds. So please prepare and diarize and get these dates written down somewhere for you to remember. The timeline for the entire competition is also accessible on the website. So please, I urge you to go to the website, www.uwmoot.com, and access all these key documents for yourself. Also, I want to urge you at this juncture, prepare as if you're the winner, okay? Prepare as if you're the winner, and you must be ready to travel. So there is a need for you to make sure that your travel documents are in place, especially for the teams coming from the rest of the other countries, with the exception of, so teams coming from Uganda, Kenya, and Rwanda, please prepare to be ready to travel. Once you are deemed as qualifying to the next rounds, after the national rounds, please, you must be ready. Have your yellow yellow fever certificates ready with you, because these are critical for immigration. Please get a passport if you have not yet gotten a passport, because we will require this to be able to make bookings for flights for you. So please prepare, do this in good time. I'm reminding you, and I'm drawing your attention to this, because this is something, if you don't have a passport, if you don't have a yellow fever vaccination card, please, this is something you can secure between now and before September. So please do so, so that once you are deemed the winning team, there are no delays for you, okay? It will help us also on our side when we need to make bookings, and early bookings at that. We don't want to get into a situation whereby we are calling on to you and then you're telling us, I don't have a passport. Please prepare. With this, I want to bring this bootcamp to a closure. Thank you so much. We have a coordination group. Please stay engaged. We are using that coordination group very much to pass on communication on different aspects. So please be sure to stay tuned into the group for any updates going forward. With this, I want to thank you all, and a good evening to you all. Bye-bye for now.